Scoundrels, written by Paul Caranci, audio by Max Bowen, and edited by Skylar Batz. It has been said that political corruption is as old as government itself. Yet despite its timeless nature and its devastating impact in society, political corruption remains an elusive term. Listen to each episode of Scoundrels for some amazing stories about greed, corruption, and arrogance that sometimes defines politics in America.
Despite complaining that he could never make any money practicing law, he loved the courtroom. In court, he was the voice of righteousness and indignation, seeking to generate sympathy for his client, pointing the finger at the accuser, the police, and the prosecutors. He had a presence, said one lawyer, a knack for understanding what was important to a jury. DeCaprio learned from the best. After graduating law school, he worked with John F. Cicilline, the father of future Providence Mayor and Rhode Island Congressman David Cicilline, and Joseph A. Bevilacqua, a future Supreme Court Chief Justice, in a thriving criminal defense practice that featured an array of mobster clients, including the New England Mafia boss, Raymond L. S. Patriarca. He also worked part-time as a lawyer for the legislature and as a public defender, a position that he eventually took on full-time. When money got tight, he left his $23,000 position with the state and re-entered private practice with Cicilline and Bevilacqua. In February of 1971, DeCaprio and another lawyer were accused of embezzling at least $4,000 from a receivership they had been involved with. Judge Ronald R. Legou called the two lawyers interlopers. DeCaprio denied receiving any money and blamed the other lawyer for the problem. In a settlement, however, DeCaprio and the other lawyer agreed to repay $4,000 to the receivership to settle a lawsuit they said would have cost them more to defend. While with Cicilline, he took part in the defense of high-profile organized crime figures. Cicilline, meanwhile, was getting close to the clients he was defending. He said it was necessary to socialize with these people, referencing his mobster clients. But these relationships were beginning to draw the attention of law enforcement. In 1978, Cicilline hired as a paralegal mafia underboss Nicholas Bianco, freshly paroled from federal prison. The next year, Cicilline, who had split from Bevilacqua, opened an office with DeCaprio on Federal Hills Atwells Avenue. Later, a few other lawyers joined them. Cicilline rented space in a building owned by crime boss Raymond L. S. Patriarca, whose vending machine business was located right across the street. On the wall hung photos of Patriarca and his son, the man who would take over as boss of the crime family upon his father's death. He and DeCaprio would routinely go for drinks with their mob clients. All of this activity gave reason for the FBI to plant bugs in the law office as part of their case against Patriarca and Bianco. While there was nothing damaging on the tapes regarding DeCaprio, the incident created enough anxiety for him to leave Cicilline and focus his practice on civil work from a new East Side office. By 1988, following his divorce, bankruptcy, and legal problems, he decided to quit the practice of law and become an insurance agent. DeCaprio wrote insurance policies and was fairly good at it. One year, he actually won a trip for two to Puerto Rico because he reached his sales quota. But he just wasn't happy outside the courtroom, and he eventually returned to the practice with the public defender's office. In 1992, DeCaprio, the man who defended and befriended mobsters, finally landed a job in the Attorney General's office as a prosecutor. Attorney General O'Neill, who had previously been unwilling to put DeCaprio in charge of organized crime cases, hired him because he needed an experienced trial lawyer to help clear a backlog of cases. The move from criminal defense lawyer to public defender to state prosecutor may be unusual, but for DiCaprio, it meant more money and a good possibility for advancement. The celebration lasted only 1 month before O'Neill suspended him when O'Neill learned of the disciplinary charges against him. The latest charges represented the second time in 15 years that he was before the disciplinary board. He pled his case, and his attorney, Stephen Famiglietti, suggested that the disciplinary board give DiCaprio the benefit of the doubt because his entire career is hanging in the balance. After conferring with Famiglietti, who said that DiCaprio would probably not be disbarred or suspended from the practice of law, O'Neill decided to allow DiCaprio to work as a prosecutor while he awaited his fate. After the election in which Pine defeated O'Neill, a mutual friend put in a good word with Pine, and DiCaprio was assigned to special prosecutions. Later, in 1993, a 3-member panel of lawyers recommended that the complaint against DiCaprio be dismissed. The full board, however, disagreed and felt that some type of disciplinary action was in order. The outcome of the case now rested with the Rhode Island Supreme Court. In December, DiCaprio pleaded for mercy before the state's 5 highest judges. Tearfully, DiCaprio said that he should have acted differently. What he did, he said, was a mistake, an isolated occurrence. He said that he should have gotten his client's permission in writing, or driven to Burrillville to get the client's signature. Ultimately, there were no public sanctions, but the court did issue a private censure. While the client never collected any money, the client's brother, another former client, sued DiCaprio for misappropriating money in other instances. DiCaprio agreed to pay $17,500 over a 5-year period so that the case would not result in a trial that might jeopardize his career. Pine's staff reorganization puts the Dupree case in jeopardy. DiCaprio was assigned to the Dupree case, but at least one member of the prosecution's team wasn't pleased. Ratcliffe felt that after 4 years working on the case, he was being pushed out. This was not Pine's only move. In a reorganization that surprised most of the 100-member staff, Pine removed James Ryan as head of the criminal division and replaced him with Michael Burns. DiCaprio was promoted to head of special prosecutions to replace Burns. In May of 1995, not wanting to deal with the internal office politics, Richard Ratcliffe resigned his position as a prosecutor, one that he had held for 7 years. In retrospect, some members of the Attorney General's office saw the moment as a critical event in the history of the Dupree case. Ratcliffe's resignation, they said, took the detail guy out of the equation, the one prosecutor who had been there from the beginning, the person who knew the complex case best. Pine's staff reorganization puts the Dupree case in jeopardy. DiCaprio was assigned to the Dupree case, but at least one member of the prosecution's team wasn't pleased. Ratcliffe felt that after 4 years of working on the case, he was being pushed out. This was not Pine's only move. In a reorganization that surprised most of the 100-member staff, Pine removed James Ryan as head of the criminal division and replaced him with Michael Burns. DiCaprio was promoted to head of special prosecutions to replace Burns. In May of 1995, not wanting to deal with the internal office politics, Richard Ratcliffe resigned his position as a prosecutor, one that he had held for 7 years. In retrospect, some members of the Attorney General's office saw the moment as a critical event in the history of the Dupree case. Ratcliffe's resignation, they said, took the detail guy out of the equation, the one prosecutor who had been there from the beginning, the person who knew the complex case best.
From students to war story aficionados, Caranci's work captivates all. Prepare to be transported to different eras and perspectives. You're sure to find a story you love and can't put down. Visit www.paulcaranci.com now to discover your next unforgettable read. Don't miss out on these captivating historical narratives. Order your copy today and start your journey through time.
Judge Dominic Cresto and Pre-Trial Shenanigans. It was now August 24th, 1995, and Judge Cresto was listening to pre-trial motions from the 7 lawyers who were preparing to either defend or prosecute the Dupreets. Defense lawyers were requesting, in addition to the 600 boxes of documents and 200 volumes of grand jury testimony, all exculpatory evidence. The evidence of any crimes committed by the state's witnesses and any contradictory statements that might have been made to the authorities that would cast doubt on the witnesses' testimony. The Dupreet lawyers also wanted to know of any promises, rewards, or inducements that the prosecutors had offered their star witnesses. In Rhode Island, prosecutors are required to supply this type of information to the defense in order to ensure a fair trial. Robert Pompeo believed that the state had not turned over all their information. Pompeo, giving the state the benefit of the doubt, chalked it up to sloppiness on the part of the state. Bruce Astrachan, the man who filled Ratcliffe's spot on the prosecution team, responded, "The defense lawyers have the testimony of all the conspirators. They have all the documents relied on in the testimony, and there should be no surprise to them as to what may come out at trial, Your Honor." He continued, "I'm not sure what the court could order the state to deliver to them, in that they have everything." Pompeo protested that by giving the defense 600 boxes of evidence, there was no way they could find the document they needed. "If the government knows where it is," said Pompeo, "they should tell us, not play games." Joseph de Caporal insisted the information had been provided, and the state shouldn't have to do the defense lawyers' work. But Judge Cresto disagreed. He determined it should not be left to the Dupreet lawyers to go through every scrap of the state's evidence for relevant information. He assigned the prosecutors the task of extracting the needles from the haystack. Astrachan argued that statements taken by witnesses by a prosecutor would be considered work product. Notes and memos reflecting legal strategies, and to those, the defense is not entitled. Cresto, in response, ordered the files turned over to him so the judge, not the prosecution team, would decide what the defense could have. De Caporal was unmoved. He believed that the defense motion was posturing. Astrachan was a new member of the Dupreet prosecution team and had only been working as a prosecutor for a year. So, despite signing his name to numerous documents indicating that the Dupreet team had everything, he was really relying on the words of Joseph de Caporal and Michael Burns. It wasn't until some time after the pre-trial hearing in August of 1995, about 3 months after being assigned to the case, that Astrachan learned otherwise. That's when he, Burns, and de Caporal met in a conference room of the State Police Financial Crimes Unit, the warehouse, for the Dupreet documents. Gina Morandi, a state police employee in charge of the records, would later testify that she had hauled in 10 cardboard boxes for the 3 prosecutors to review. The boxes contained the work files of the original Dupreet investigators. The 3 men spent almost the entire day reviewing the boxes and taking out those documents they believed they would have to give to Judge Cresto. Burns later testified that he didn't stay that long, and that he allowed de Caporal and Astrachan to do most of the work. But Morandi recalled that the men reviewed information damaging to Rodney Brusini, the state's star witness. The information could be dynamite in the hands of the Dupreet lawyers, enabling them to attack inconsistencies in Brusini's story and to argue that he had agreed to testify against Edward Dupreet to avoid a perjury charge. When they had finished, many documents remained that would not be turned over. Among them were files concerning Brusini, including information bearing on whether he had committed perjury. Burns was the man assigned to question Brusini. He should have been aware of every document that related to his witness, but he had other things on his mind. His new position was very demanding and pulled him in several different directions at the same time. He was going through a very messy and public divorce with Patricia Nugent Burns, his wife and office aide. Patricia, in a drunkard state on May 18, 1995, called 911 and reported an assault on her by Burns. Johnston police eventually dropped the case, but the tape of the 911 call was played on a local TV station, something that proved very embarrassing for Burns. While Burns was responsible for questioning Brusini, it was DeCaporal who had the responsibility of complying with Judge Cresto's order to turn over all evidence to him or the Dupreet lawyers. Egbert was right to be suspicious. DeCaporal had a history of withholding evidence in trials. In a case involving real estate developer James Prakashanti and his uncle, a case in which they were charged with defrauding former Marquette Credit Union of $500,000 in loan money, he failed to turn over evidence that significantly weakened the case against Prakashanti. The charges were eventually dismissed when the case went to trial. Egbert suspected that the state was withholding something about the only man who had testified that he delivered kickbacks directly to the governor, Rodney Brusini. Through private investigators digging into Brusini's business dealings, Egbert concluded that Brusini had pocketed the alleged kickback money. Then, with the police closing in, Brusini had implicated Dupreet to save himself. The state had turned over documents regarding Brusini's statements from 1992 and 1994, but he had received nothing from the year 1993. Egbert wondered if Brusini made statements that year that might be helpful to the defense. Dennis Dupreet's lawyer was also checking into the background of Frank Zano, the chief witness against his client. Pompeo, like Egbert, would argue that Zano kept the money he had claimed to have given Dennis Dupreet. Pompeo was interested in the lavish lifestyle that Zano lived, one that included spending money on a condominium in the Caribbean, high-performance cars, and a younger woman who was not his wife. Pompeo was especially intrigued by $150,000 that Zano kept in banks in St. Martin in Florida. Zano told the prosecutors that he had won the money gambling, but Pompeo said that his private investigators could find no such evidence, not at casinos at Foxwoods, Atlantic City, or Las Vegas, not at racetracks throughout New England, not even with underworld bookies. As the trial approached in 1996, Pompeo felt the outcome of the case was still very much in doubt. He was unable to find the smoking gun needed to destroy the state's case. Then, on the eve of the trial, in May 1996, the prosecutors gave the Dupreet lawyers some documents that they said they had just found, including previously undisclosed statements from Brusini and Zano. The prosecutors would later point to their provision of this material to underscore their contention that they had not deliberately withheld evidence. The two defense lawyers immediately filed another motion for discovery. In response, the state handed over even more documents. But still missing was the document showing the state's agreement for immunity from perjury for Brusini. Astrakhan insisted that the defense had everything. The debate came to a head during a July 25, 1996 conference call that resulted in Judge Cresto again ordering all prosecution documents turned over to him for review. Gina Morandi, the state police custodian of the records, informed DeCaporal that there were still some 30 boxes of material in her custody. Defense lawyers were overwhelmed at what they were presented with a few days later, when they arrived at the Attorney General's office. The boxes contained 68,000 pages of documents. Just to copy them would cost $20,000. On August 16, 1996, Pompeo and Egbert asked Judge Cresto to dismiss all charges on the grounds of prosecutorial misconduct. Once again, the prosecution denied withholding evidence and said that they had handed over all documents crucial to the case. The defense said the new material contained the first clues that Brusini had lied to a grand jury. when he denied any ownership interest in a building he had rented to the state, and that he had been given an undisclosed promise of immunity by the state. Brusini's lie, and the state promise not to prosecute him, came to overshadow the question of guilt or innocence of former Governor Edward D. DePreet and his son Dennis L. DePreet. On October 21, 1996, Judge Cresto began the hearing on the defense motion to dismiss the case. Kathleen Haggerty was assigned to represent the prosecution at the hearing. Haggerty had a reputation for working hard to prepare for her cases. She had won some major convictions, including a case against a former Pawtucket special prosecutor, Frank Matera, of soliciting a bribe to fix a drunk driving charge. But she had earned some critics in the process. 4 judges told Judge Joseph F. Rogers, Jr. that Haggerty was self-righteous and pushy, both with opposing lawyers and with witnesses. On the stay, she chose to argue that Judge Cresto had no right to even be hearing this motion. The state, she said, denied any prosecutorial misconduct. But even if the prosecution had secreted evidence, she said, the remedies are quite limited, and in fact Your Honor may not impose sanctions to penalize the prosecutors. The state attempts to make Ratcliffe take the hit for withholding information. A few days before, Richard Ratcliffe had a lunch meeting with Haggerty and DeCapero. During that meeting, both lawyers pressed Ratcliffe about the immunity deal he made with Brusini. They asked Ratcliffe if he had ever informed anyone else within the office about the deal. Ratcliffe insisted that he had, but in later testimony said that as a result of the questioning, he had gotten the clear impression that he was going to be used as a scapegoat and that everyone else would deny having any knowledge of the deal. The defense called their first witness, Brusini lawyer, Richard A. Gonella. He testified that his very first action was to insist on an immunity deal against his client for any perjury charges that might be pursued. He explained that he worked out such an agreement with Ratcliffe and told DeCapero about it. While Gonella was still on the stand, state investigators called Ratcliffe and asked if he could come to the courthouse. He was the only person that could verify or refute what Gonella was saying. Ratcliffe insisted he couldn't get to the courthouse. A few minutes later, the investigator walked into Ratcliffe's office and handed him a subpoena. Ratcliffe arrived in the courthouse and waited. He was eventually allowed to leave. The next day he showed up at the Attorney General's office to review documents for his testimony. While there, Pine and his deputy, Thomas M. Dickinson, appeared and asked Ratcliffe about the immunity deal that had been arranged for Brusini. They were splitting hairs about whether Ratcliffe had made a promise or offered a reward or inducement. To Ratcliffe, there was no difference. However, Ratcliffe did tell Haggerty that James Ryan had notes from the meeting at which they discussed immunity that would show that Pine and Dickinson were in attendance. Even though he intended for Haggerty to use that information to turn the notes over to DePreet's attorneys, the AG's office waited 10 more days before telling them about the notes. Ratcliffe testified that before he left the Attorney General's office, he walked Astrakhan through all the DePreet files and recently called him to advise him to amend the state's written declarations to reflect the Brusini perjury promise. Astrakhan denied that Ratcliffe ever told him that. Astrakhan was on the witness stand for 6 days, being grilled first by Egbert and then by Pompeo. Suddenly, it seemed, it was the good guys who were on trial. It was Astrakhan's signature that appeared on most of the signed documents, indicating that all documents had been turned over to the defense. He was now saying that he hadn't read all the material. He simply signed the papers, as a matter of convenience. Astrakhan was actually admitting that he and his fellow prosecutors had erred in swearing in to the court that they had turned over all the evidence. And, he said, the prosecutors had been wrong to attack the DePreet lawyers as incompetent liars for having said that evidence had been withheld. Astrakhan was getting destroyed on the stand. DeCapero would later say that he never should have let the kid sign the papers. Haggerty was concerned about how the defense lawyers were making him look. During a sidebar, she expressed concern to Judge Cresto that the lawyers were setting Astrakhan up for disciplinary action, but there would be no rest for Astrakhan. Pompeo took the next shot, getting him to admit that the AG knew about the bank accounts that Frank Zeno, the key witness against Dennis DePreet, opened in his children's names to hide money from his wife during the divorce. Even though the asset reporting forms for divorce cases are signed under oath, the AG's office took no action against him and never notified the family court. It was the testimony of Michael Burns, though, that really set the prosecution's case on its ear. Burns took with him to the stand a detailed memo that summarized the DePreet investigation. The memo had been written by the original prosecutor of the case, J. Richard Ratcliffe, and given to Jeffrey Pine when Pine succeeded James O'Neill as Attorney General in 1993. When Pine took office, Brusini was seeking immunity for various crimes, but no deal had been struck. "We were prepared to indict Brusini for perjury and ethics violations," Ratcliffe's memo said. Prosecutor Burns, under questioning by DePreet lawyer Richard M. Egbert, conceded that he and Attorney General Pine had both read the memo in January 1993, but Burns said he'd forgotten about it until he rediscovered it just the week before. When DeCaprio had learned about Burns's memo just moments before Burns took the stand, he said, "This is going to look bad." Burns was on the stand for 11 days, spread over several weeks, but became ill before completing his testimony. He was replaced by James Ryan, who testified Pine and his prosecutors had discussed the possibility of offering Rodney Brusini immunity from perjury charges. Burns eventually returned to the stand, but things didn't get any better for the prosecution. At one point, Burns testified that he had just recently found out that there were several boxes of audio tapes of Brusini's grand jury. He eventually handed over 20 tapes to Judge Cresto. Ratcliffe, however, testified that he told Burns about the tapes and instructed him to turn them over to DePreet's lawyers. On another day, the court was told of 11 spiral-bound notebooks of notes taken by Peter Blessing, one of the original investigators. Gina Morandi found them in a file cabinet drawer. Morandi testified that Astrakhan lied when he said that the DePreet lawyers now had all the evidence to which they were entitled. She also told about Burns, Astrakhan, and DeCaprio culling through evidence instead of providing everything to Cresto. For her efforts, she was called to state police headquarters, where she was read her rights and told she was a suspect in the crimes of obstructing justice and perjury relating to her finding the 11 notebooks. She was never charged, but she was removed from the DePreet case. Cresto was not happy about what he was hearing. He knew that the public expected the DePreets to stand trial. Their indictment in 1994 for bribery, racketeering, extortion, and perjury represented one of the biggest public corruption cases in Rhode Island history. The thought of dismissing corruption charges against a former governor before a jury could hear the evidence did not sit well with the judge. Moreover, Cresto's earlier dismissal of part of the DePreet case had been overturned by the state Supreme Court. Yet, in failing to turn over the evidence, the prosecutors had violated the judge's orders, the rules of the Rhode Island courts, and the U.S. Constitution, and that was something Dominic Cresto was not going to tolerate. Pine removes Burns, DeCaprio, and Astrakhan from the case, but can't stop the judge from ruling for the defense. On February 17, 1997, Pine announced he was replacing the prosecutors in the DePreet case. Pine said he was making the change because it is clear that the DePreet lawyers may try to call prosecutors Michael Burns, Joseph DeCaprio, and Bruce Astrakhan as witnesses in the trial, which would prevent them from serving as advocates for the state. The new prosecution team would be Assistant Attorneys General J. Patrick Youngs III, Michael J. Stone, and Special Assistant Attorney General Kathleen M. Haggerty. March 11, 1997, turned out to be the last day of the 32-day pretrial hearing. Cresto asked his court secretary to type up the 38-page decision. While not ruling on the Dupreets' guilt or innocence, Cresto wrote, "The manner and magnitude of the prosecutorial misconduct found by the court to exist in this case has not only resulted in substantial prejudice to the defendants, but has the effect of eroding confidence in the criminal justice system." He noted that the state has repeatedly violated his orders, the state court rules, the U.S. Constitution, and their own agreements with the Dupreet lawyers to give them critical pieces of evidence. The situation raises the alarming specter that the system works only if an accused has the financial resources to make independent investigation prior to trial to ferret out misconduct, to endure due process. Dismissal of the case, Cresto wrote, was the only way to impress upon the prosecution that it cannot be allowed to benefit from having acted in a manner that is less than constitutional and ethical in the pursuit of convictions. Just like that, the case against the Dupreets seemed to be over. The Rhode Island Supreme Court weighs in on the Dupreet case as a former prosecutor commits suicide. Attorney General Pine saw it as his final chance to bring Governor Dupreet and his son Dennis to trial. And so the accused and their accusers, the lawyers, the families, the investigators, and the curious gathered on Wednesday morning, November 12, 1997, for the oral arguments in the prosecutor's appeal of the dismissal of the corruption case against the Dupreets. As the justices took their seats, the arguments began. It had taken 4 years to reach this point, and now all Michael Burns could do was stand, arms folded, in the rear of the courtroom. It was apparently more than he could bear. Either late Saturday night or early Sunday morning of the week before Thanksgiving, the chief of the Attorney General's Criminal Division walked into the snow-covered woods near his secluded Johnston home and fired a single gunshot into his head. 39-year-old Burns was dead from suicide. The Supreme Court, based on the arguments just presented, would decide if the Dupreets would go on to trial. Chief Justice Joseph R. Weisberger, 77, was keenly aware of the public's cynicism toward government, having served through scandals that had toppled his two predecessors, Joseph A. Bevilacqua and Thomas F. Fay. When Weisberger succeeded Fay in 1993, he had pledged to restore public confidence in the Rhode Island judiciary. He wanted desperately to do that when he suggested that he and his associates reinstate the charges so that the Dupreets could go on trial. He argued that Superior Court Judge Dominic F. Cresto had had no authority to dismiss the case. Weisberger didn't want to punish the people of Rhode Island because of mistakes that may have been made by the state, mistakes that were eventually corrected, ultimately causing no harm to the defense team. But Justice John P. Boursier disagreed. Long considered the brains on the trial court, Boursier had a reputation for handing out stiff sentences. But he was a relatively new member of the Supreme Court. He argued that the case should be thrown out because of the misbehavior of the prosecutors. Cresto, he argued, had been within his authority and supported his position with state and federal case law. If the Supreme Court ruled otherwise, Boursier said, it would be bending the law to achieve a politically popular result, a trial of the Dupreets. The case would now be up to the 3 remaining justices to decide, but 2 of the members had conflicts. Robert Flanders had served as Dupreet's legal counsel, while Maureen McKenna Goldberg had been appointed to the court by Dupreet. Each had to be recused from participation. To replace them, Weisberger chose retired Supreme Court Justices Florence K. Murray and Donald F. Shea to hear the case. Victoria S. Lederberg, a former state senator, was the other member. Despite some friction between Murray and Weisberger in the past, Murray agreed with him on this issue. Lederberg, on the other hand, seemed to support Boursier's position. The case, in essence, now came down to the feelings of Donald Shea, and he agreed with Weisberger and Murray. The Dupreet case had gained new life. On January 9th, 1998, the Rhode Island Supreme Court issued a one-page order reinstating the charges against Edward and Dennis Dupreet. The ACLU asks the Supreme Court to investigate the Attorney General. In February of 1994, Pine still had a 60% approval rating according to Brown University polling data. But controversy over Pine's narcotics strike force and the Dupreet case have raised questions about Pine's judgment and generated the criticism that the Attorney General does not always fight fair. Now, the ACLU asked the Supreme Court's Disciplinary Board to determine if Pine had acted inappropriately in the Dupreet case. Pine responded that the complaint was without merit because David Curtin of the Disciplinary Board had already informed the AG staff that there were no improprieties in the Dupreet case. Curtin, however, insisted the matter was still under review and that there would be a lot more to come. Pine's strike force was also experiencing problems with informants, and a case was dismissed as a result. FBI agents actually removed boxes of files from Pine's office and assumed authority over the case. On March 4, 1998, Attorney General Pine said that he would not seek re-election to the position that he had held for 6 years. He felt it was time to re-enter private practice, where he could earn significantly more than the $55,000 he was making as Attorney General. 8 years after the first tip reached investigators, the case of the State versus Dupreet still had not gone to trial, and the new Superior Court judge, Francis J. Darrigan, Jr., had a new issue to deal with at a hearing before the lower court. This time, the Dupreet attorneys were asking the court to award $1.2 million that it cost their clients to have them pour through 600 boxes of documents for items that were never handed over. They noted that the Dupreets had incurred legal fees exceeding $3 million to date. In addition to the money issue, Kathleen Haggerty continued to irritate the court when she explained to Darrigan that her office disagreed with the Supreme Court. The prosecutors, she said, had not engaged in misconduct in the discovery process. The judge, peering over his reading glasses, ordered Haggerty to sit down. "I don't need to be lectured by you, Miss Haggerty, on what constitutes discovery." The Dupreets strike a plea denying the people of the state a trial. Judge Darrigan set a trial date of January 4th, 1999, but on December 11th, 1998, after almost 4 years of proclaiming their innocence, the Dupreets stunned the people of Rhode Island by deciding to accept a plea. Former Governor Edward Dupreet pleaded guilty to 18 felony counts of racketeering, extortion, and bribery as part of a plea bargain with state prosecutors. In the same courtroom, Dennis Dupreet, who stood accused of being his father's bagman, pleaded guilty to one misdemeanor charge of soliciting an illegal $1,000 campaign contribution. He paid a $1,000 fine. As part of the deal, then Attorney General Jeffrey B. Pine agreed to drop all of the felony charges against Dennis. In accepting the pleas, Superior Court Judge Francis J. Darrigan, Jr. told Edward Dupreet, "You have forever disgraced a proud family name and have caused you and your family to suffer humiliation and derision solely because of your surrender to greed and avarice. More importantly," Darrigan said, "you have broken faith with the Rhode Island community, which on 3 occasions honored you by electing you to Rhode Island's highest public office. You have betrayed the public trust bestowed upon you, and this is most reprehensible and contemptible." Dupreet was sentenced to 1 year in prison. He was allowed to work at his family's insurance company during the day, and was confined to prison at night and on weekends. He would serve only 11 months in prison before being released early. Retirement Board revokes ex-governor's pension while Dennis expands his asset base. But for Ed Dupreet, the struggle wasn't over. The former governor lost his license to sell insurance, and in January 1999, the State Retirement Board moved to strip him of his pension, which he had been receiving for 8 years. Dupreet had accumulated the pension, serving in a long list of public service jobs that started with his service on the Cranston School Committee. His career brought him to the city council and the mayor's office, and then to the governor's office. He also served in the United States Navy. His annual state pension was $50,777. When his pension was finally revoked in November of 1999, Dupreet had already collected $380,613.75. In revoking the pension, presiding Justice Joseph F. Rogers, Jr. cited Dupreet's dishonorable service as governor, calling his crimes both extraordinary and unprecedented. Rogers agreed with Patricia Dupreet's claim that she was an innocent spouse. However, he said she wasn't entitled to any part of the pension because neither she nor her husband had provided enough information on her financial condition. Even as the former governor was led into the courtroom in shackles, he refused, on at least a dozen occasions, to discuss his family finances, invoking his Fifth Amendment rights on advice of legal counsel. Since his release from prison, Dupreet has limited any discussion of his finances to his legal defense debts, which totaled over $1 million. By 2004, Edward and Patricia Dupreet had sold about $2 million worth of real estate they owned. The Dupreets appealed the pension ruling to the Rhode Island Supreme Court. But while the former governor was liquidating assets, Dennis and his wife were scooping them up. In debt to the tune of over $3 million in legal defense bills, Dennis Dupreet and/or his wife Susan have acquired 2 Waterview lots off Ocean Road in Narragansett. They built a fairly extensive home on one of the lots, a house that has 12 rooms, 5 bedrooms, and 4.5 baths, and, according to sources, a home movie theater in the basement. A staff member in the office of the Narragansett tax assessor calls it the nicest estate in Narragansett. The 2000 tax assessment totaled $2,855,700, with an annual tax bill of $18,051.78 that was paid in full in advance. The Dupreets paid $650,000 for the raw land. The title to the property is held in the SFD Trust, created by Susan Dupreet. WBR LLC purchased the second lot. Dennis paid $600,000 for that piece in February of 2001. Even before Dennis took ownership, he received an offer to purchase from Dennis Gray, a Lincoln contractor who offered $875,000. Dupreet later rejected the offer and was sued by the contractor. Dennis's brother, Thomas, an attorney, valued the property at $1.2 million in court documents. The parties reached an out-of-court settlement. Stories of traditional political corruption, both active and passive, as exemplified in these stories, make headlines somewhere in the world almost on a daily basis. They are intriguing to read and almost hypnotic in their ability to breed complacency on the part of the electorate. The effects of traditional political corruption are many and devastating, from lost economic opportunity to higher taxes to a distrust of government and politicians. Traditional political corruption tears at the fabric of our society, leaving only disappointment and economic destruction in its wake.
Listen to next week's episode of Scoundrel to find out what happens next. Politics, corruption, and so much more. Follow along. Thanks for listening.
Elite Handyman Services, over 35 years of trusted residential and commercial expertise. Elite Handyman Services is reminding motorists to slow down in residential zones and arrive alive. Never text or drink and drive. Elite Handyman Services, a name backed with over 35 years of experience in residential and commercial work. A full-service handyman. From home improvements, remodels, electrical, construction, plumbing, they do it all. 401-246-4197. That's 401-246-4197, or log into EliteHandymanServicesLLC.net. Professionals who care.